Everyone for joining this webinar today. We're excited to have James Brody, the senior partner at Garris Horn, join us today to talk about hire and recruit with confidence. This is a recorded session, so we will be sharing the presentation and the recording with everyone afterwards. We do want to answer your questions, so if you have questions throughout the session, please put that into chat. And what we'll do is, if we have some time afterwards, because there's a lot of content to be covered, if there's some time afterwards, we'll be sure to answer your questions. But if there's not enough time to answer all the questions, we'll be sure to put it into an FAQ for you when we consult with James afterwards, and then we'll share it with everybody. So please share your questions with us. With that said, I'm going to turn this over to James. Thank you for joining us today, James.
All right. Well, thank you, everybody. First off, I'll be leading you through today's webinar, which is titled Hire and Recruit with Confidence. Best practices to mitigate and defend against claims for poaching and solicitation. I'm confident, I'm hopeful that you'll find the information that we review today to be helpful as we all continue to navigate ever-changing world of regulatory compliance. But before we get into the meat of today's presentation, I want to quickly go over some administrative issues, which I'm sure you've heard all the time before if you've ever attended any webinar with a lawyer. So the disclaimer is that nothing in today's presentation constitutes legal advice or creates an attorney-client relationship between the parties to today's webinar. With that being said, again, as Mimi said, my name is James Brody, and I'm a senior litigation partner over at Garris Horn with nearly 20 years of experience in the mortgage industry. I manage all the complex mortgage banking litigation, mitigation, and compliance matters for our diverse clientele. And I serve as lead litigation counsel for numerous mortgage banks in disputes such as these. As far as Garris Horn, we're a boutique mortgage banking firm composed of nationally renowned attorneys from government, large firms, and top companies in their fields. We were originally founded by a couple of partners, one whom is the former CFPB attorney and special advisor, who is Richard Horn. And let me go ahead and get this right. All right. And so maybe you can go ahead and give a little bit of information about, TMC and everything it is you guys do.
Thank you. Would love to. I appreciate the opportunity. So I know there are a lot of lender members as well as lenders who are not TMC members on the call today. Just to give you a little color on TMC, we are an organization that is 11 years old. Our founders just wanted to create an area where small to mid-sized lenders can compete with other larger lenders. So they created the Mortgage Collaborative. The Mortgage Collaborative really focused on creating an environment of collaboration and innovation for our lender members. We are focused on an experience driven by focused on members. So we like to help them create, foster, and encourage, through family-centric, pay-it-forward type of culture. So TMC today has about over 200 members, lender members, and we have about 75 preferred partners on our platform. Some of the benefits that you get with TMC includes access to TMC benchmarking. We have virtual education and networking events. We have access to industry professionals, and we help our lenders exchange best practices through our working groups, as well as collab labs. As well as access, of course, to benefits and savings through our preferred partners. If you'd like more information, please reach out to me. I'd be happy to provide you with more information afterwards. Thank you, James, for the opportunity. I'm going to turn this back to you.
All right, Mimi, thank you very much. And again, welcome, everyone. I would say that this is an important topic, especially now, but I think that's true, at any time, really. When it comes to poaching, hiring, recruiting, that is the lifeblood of our industry. When we're doing M&A work, we're not talking about desks, we're not talking about computers, we're talking about the talent, the loan officers, the people that are making the production. So That is and continues to be and has always been the mortgage industry's greatest asset. So when you are looking at improving your company's business, when you are looking at taking it to the next level, you're talking about getting top producers, and top producers that aren't just going to, be here for making a buck today, but that are going to do things the right way, that have those relationships. And so, how do you go ahead and hire those people without fear of being sued? What do you do when you have a loan officer, a branch of loan officers who ups and leaves you and takes a significant amount of business? Um, in many cases, this type of situation is generally dealt with outside of court, because no one wants to air their dirty laundry, or no one wants to put it out there and maybe have an impact on your own loan officers. Because if they see the way that maybe you behave or act in one particular situation, that may turn them off. Now, that being said, you may want to set an example to the rest of your loan officers. If you have an LO or a branch that does something wrong, well, maybe you don't want that to happen again. And so you want to set an example. These are the types of situations and circumstances that our clients come to me to talk about and to address, both on the offensive and defensive side. They say, James, look, we are growing our practice. We got a couple of great producing LOs that want to come over from a competitor, but we're worried. We don't want to go ahead and make or cut off our nose to spite our face and get some cash in the door, and then have to spend it all on someone like you to go ahead and defend us. So how do we do this the right way? How do we do this in a way that is going to make sure that when we inevitably get a letter from our competitor, which tends to be a cease and desist letter, that we're able to go ahead and address that? How do we now, James, being another client, we just lost a loan officer. We just lost a branch. What do we do? A significant amount of business is gone. We don't know if there's a data breach. We don't know what to do with the consumers. We don't know what loans they took. How can we go ahead and address this? Well, the bottom line here is that you need to be able to have plans, systems in place to address both of these situations. Let's go ahead and take a look at this agenda. There's a lot of ground to cover, and we're certainly not going to get to all of it today. But as I think Mimi might have said, please ask your questions along the way. And if I'm not able to get to it at the end, what I can do and will do is prepare a follow-up FAQ that will address each and every one of your questions. I will send that over to Mimi and the folks over at the Mortgage Collaborative, so that you can go ahead and have all your questions get addressed. And if for some reason, of course, you think of a question later, you are more than welcome to reach out to me, and I'll be happy to discuss. Because right now, with the market the way it is, and even though this is always a concern, we see a lot of movement, a lot of migration from various companies, whether it's M&A work, which we do a lot of, or whether it's poaching related issues. We go through various phases in this industry, and the phase that we are in right now, you will be seeing a lot of consolidation. You'll be seeing a lot of announcements in the marketplace. So the various items that we're going to talk about today in some detail are, the types of agreements, the no poach, the non-compete, non-solicitation, and non-disclosure agreements. We're also going to go ahead and talk about the FTC announcement with respect to non-competes, which have been unfavored or banned in a number of states, and it's really just trying to give ultimate effect to that. But it's still in a state of clients wanting to understand how to go about dealing with that non-compete, how to protect themselves. We're also going to talk about data privacy and data security. Whenever you have a loan officer leave your company, if they go ahead, I'll give you an example. I have a situation which is like many. A few key LOs wanted to go to a new company, and rather than just going ahead and going over there, they thought it would be a great idea to take a pipeline of hundreds of loans with them. Now, obviously, that puts them at risk. It puts their new employer at risk, but the company that they are leaving is now at risk as well because there is a data breach. And that would go to the damages that you would need to look at if this were to happen to your company. And we'll talk about, things that you can do to try and, figure out whether or not that is an issue. And that could include getting your IT, and generally is getting your IT to start looking through all the emails, looking at any digital imprint or footprint, rather, that may have been left. Has there been communications with the new company? Has there been communications with other LOs who they were soliciting along the way? Is our emails going to the consumers? There's a lot of information there, and usually when this does indeed happen to that degree, most of the time we're able to settle those cases out of court, because the last thing you want is, again, to have that dirty laundry aired, and for the company that is it happened to. You may want to set an example, but at the end of the day, you want to be compensated. You want to make sure that any damages that were caused to you as a result of a migration that was done inappropriately, incorrectly, that you are taken care of. And so we'll talk about the data security. We'll talk about the data privacy. We'll also talk about LO comp. Anytime, and I mean, I can say this 95% of the time, let's say, when I go after a loan officer or I go after the competitor who, inappropriately took the key producer and or his or her branch, they will raise that they were not paid properly, that the company they're leaving had failed to pay them, whether it is OT or, they failed to pay them properly under the LO comp rules. But the bottom line here is that they will go ahead and do anything and everything that they can to, deflect, offset the exposure that is being, the former employer is going after. So those are some of the issues that we will go ahead and get involved. Now, when you are looking at whether or not to air your dirty laundry. And remember, just a few moments ago, I said that primarily these things are dealt with outside of court. Well, things are changing. In June of 2023, Loan Depot had sued Movement Mortgage, claiming it illegally lured away 25 employees in 6 states. Now, headlines read that Movement Mortgage used all expenses paid recruiting trips to entice employees to leave Loan Depot and take the company's trade secrets with them. According to the 27-page complaint, Loan Depot believed Movement's targeted recruiting and hiring of company employees had gone beyond mere market coincidence. In January 2024, Guaranteed Rate filed suit and an injunction against New American Funding, alleging that New American Funding wooed at least 30 employees since early 2023. And like Loan Depot, Guaranteed Rate had claimed these aggressive poaching tactics were being used. Now, again, we all know that the FTC had issued a final rule to promote competition by banning non-competes nationwide. This protects workers' freedom to change jobs, increase innovation, and foster new business formation, or at least that is the spiel given by the FTC and its advocates. The FTC had estimated that it would boost new business formation by 2.7% annually, or approximately 8,500 new businesses per year. So what are we really talking about? And I guess that's what we're going to get into this morning or afternoon, rather, wherever you're at. going back to guaranteed rate and their lawsuit against New American Funding for the poaching or the alleged poaching, it's also unique for another reason. In the lawsuit, it was stated that to achieve its goals, New American used allegedly illegal compensation practices to induce these employees to resign and join their company, as well as incentivized and encouraged guaranteed rate employees to solicit and recruit other employees to defect to New American. Now, again, these are allegations. I am in no way saying that any of these representations are true or false. It's just but what is out there in the public domain, and I think is a great example of what's happening here. Now, there's no doubt there's, again, a rise in the poaching litigation due to the competitive market, but this lawsuit is the first time that a large lender had publicly accused a competitor of violating the LO comp rule by allowing their sales force to manipulate lead sources and to reduce rates and win more loans. Now, during that same period, you had seen Housing Wire did a article stating that industry experts have been observing widespread manipulation of lead sources among the retail lenders with no enforcement. All right. There we go. So there's four main types of agreements that have clauses that can prevent an employee from receiving or accepting a competing employment offer, or at least attempts to. You have no poach agreements, non-compete agreements, and that is what the subject of the FTC rule is, non-solicit agreements and non-disclosure agreements, or agreements with various provisions of this nature contained therein. So what is a no poach agreement? Well, these are probably the least heard about in our industry. No poach agreements are effectively promises between companies not to compete for each other's employees. And it can be in writing, or it can be verbal, and the restriction can be on one or both of the parties. These agreements may restrict recruiting, solicitation, hiring, or similar competition for workers, impacting an employee's ability to move from one company to another. And with our firm doing a lot of M&A work, this is where we'll typically see these types of clauses, as well as in NDAs and settlement agreements resolving business disputes. But in the main, they are not something that you will commonly see. But it is just one type of agreement that I wanted to make mention of, because many people don't even know about that. All right, non-compete agreements. Now, these are the agreements between your companies as well as your employees that they will not compete for certain customers within your industry, our industry, or within a specific geographic area for a set duration of time. And these clauses come into effect only after the employment relationship ends. Now, there have been cases where the DOJ or the Department of Justice filed statements of interest with antitrust concerns, notably in the healthcare industry. But generally, non-competes had been a creature, and still are in many regards, of state law, state statutes, as well as common law. In Oregon and California, where these were the first states to create encompassing statutes, against non-competes, and they're essentially attempting to balance, the employee's interest with the employer's interest. But at the end of the day, you want to make sure that people have a freedom to move, that they are not handcuffed, that they're not going to be out of work because their profession, they're not able to do anything in that because of an agreement like this, even after something goes south in the relationship. So I understand, why non-competes, are getting the treatment that they are. That being said, the FTC and a lot of creative legal minds have found ways to, circumnavigate around the non-compete. Although the FTC did make it clear that if you have other provisions in your agreements that are tantamount to a non-compete, well, that could be violative as well. So you always want to, and that's really what we've been doing a lot of, is taking the employment agreements, whether on LO comp and or to try and build in provisions that will protect companies, even without a non-compete. And that means tightening up your non-disclosure, your confidentiality, your trade secret information. Although there are certain exceptions for, individual C-suite folks, in the non-compete arena where that would make more sense as well. So let's go to the non-solicit agreements. Non-solicitation agreements can be broken down into two subcategories, B2B or business to business and employee to employer agreements. Non-solicit most commonly is between an employer and employee, and it prohibits an employee from using the company's clients, customers, and contact lists for personal gain upon leaving the company. In B2B agreements, service or relationship contracts often contain a provision that each party will not hire or solicit the other employees. And you see this often in consultant contracts. And I can tell you that this had come up in a very negative way in a recent experience, as we have a situation, and let me just talk about it in hypotheticals, but we have a situation where there is an expert or a consultant and a client or a customer took away their talent. And so you can see these types of agreements in a number of different contexts, not just the employer and the employee. Now, non-solicit agreements are restricted in certain jurisdictions, notably such as in California. It's, an agreement that's too broad may violate standards of reasonableness, which are decided on a case-by-case basis. And under common law, an overarching agreement would be deemed a restraint on trade and thus invalid. For B2B, no hire provisions are inherently riskier than no solicit provisions, which may have a legitimate business purpose. Now, non-disclosure agreements. An NDA is a legally binding agreement creating a confidential relationship between disclosing and receiving parties. It prevents the receiving party from revealing sensitive information to unauthorized third parties. Confidential information is often sensitive, technical, commercial, or valuable in nature, trade secrets or proprietary information. Both parties sign the NDA, creating a binding agreement to keep that information secret, confidential. NDAs have both offensive and defensive uses, with the defensive uses, creating the boundaries and preserving the rights of the information. Offensive uses are to preserve trade secrets, clarify the confidential nature of interactions, and protect information from theft or use by former employees. Of course, NDAs are in so many different contexts. They are one of the most critical tools that can be used. And so anytime you have your agreements that need to be revised, you really need to take a look at having your counsel tighten up those provisions, finding out how to go ahead and use what's out there right now on tightening up non-disclosure, confidentiality, non-solicit, to work around the non-competes and to do it in a way that will, ultimately hold muster. Now, let's see here. Going to the FTC. On July 9th, President Biden had ordered the FTC to fully ban or limit the employer's use of the non-competes. And the FTC, as we just talked about, which regulates advertising, marketing, and consumer credit practices, and also prevents antitrust agreements and such, had done exactly that. Although it has no authority to punish the violators, it can monitor compliance with the trade laws, conduct legal investigations, issue cease and desist orders, convene public hearings, file civil suits, and ensure the court orders get adhered to. In one of the most highly anticipated employment law decisions, the FTC long-awaited rule on non-compete agreements was finalized this past April. The FTC non-compete rule bans all new non-compete clauses with workers, except for senior executives, as I was mentioning a short while ago, your C-suite folks. And as far as existing non-competes with workers, except for those senior executives, they would be unenforceable as of September 4th of this year. The final rule prevents employers from entering into non-compete clauses with workers. Again, there are non-competes that can be used for certain C-suite folks. There are ways to work around that. But it's not a black and white type of situation. It's in that gray area that us lawyers love to live in. But there are ways to make it tighter. And when you are making it tighter, you want to make sure that you respect the purpose of what the FTC was trying to do, or its intention. Because if you're able to do that, you have a much greater likelihood of your alternative restrictions holding up in court, which you hope you never get to that point, but hope doesn't always prevail. So that's something that you really need to consider. Now, in August of this year, the U.S. District Court for the Northern District of Texas had ordered that the FTC commission's broad non-compete, the final ban. It said that it was unlawful and stopped it from taking effect on September 4th, as had been scheduled. The decision applies nationwide, meaning the FTC's final rule cannot be enforced at this moment. However, again, it's banned already in many states, and it is something that is going to be, I think, inevitable. Whether it's going to be a month or a year, the bottom line is to make sure your companies are safe and that you are not getting hit by this or by the state laws that prohibit this. You need to go ahead and, again, consult your lawyer, talk about those alternative provisions. And I think it can also be turned on its head and used as a recruiting tool because, again, you want people to know that you want them there because they want to be there. You don't want to handcuff someone. And if you show them that you have an agreement that has a fair amount of parity, a fair outlook, a fair arrangement. They may say, well, that's the type of employer that they want to work for. And there are ways that you can also address issues on the back end if they do ever want to leave, because you don't want to keep these people. If they don't want to be there, it could end up causing you a lot more problems than it's worth. And that could be things like agreeing how you would divvy up, production. Is it something that is a company-generated lead? Is it a self-generated lead? Is it, where is it in the process of getting closed? Where, has credit been pooled? I mean, there's a lot of different ways that you can address that. And if you do that up front, while you certainly don't want to have, I guess, a prenuptial agreement, in this context, it may be good, especially when you are talking to those, potential high-producing LOs that you want to recruit. A fair amount of work doing it on the front end will save your backsides on the back end. And certainly the amount of money that it may take to deal with that after the fact is well worth that. Okay. Now, what's more prevalent that we see, I guess, in our industry isn't necessarily the non-competes, but really coming down to the non-solicit, because while you don't want someone to stay that doesn't want to be there, you certainly don't want them, throwing a grenade into the office or the company as they are leaving and trying to get all of those other key producing LOs to migrate with them. Whether it's intentional interference with the contractual relationship, there's a lot of damages that can be caused from the solicitation here. All right. A non-disclosure agreement, also refers to as the confidentiality agreement, is also very prevalent in our industry, and it prohibits the employees and the independent contractors from disclosing any of that confidential information. NDAs serve companies to protect info about their operations, your processes, secrets, or other information that's so important to your market standing and your competitive position, because our industry is nothing if not competitive. All right. Enforceability. Let's see where the restrictiveness of non-compete, non-disclosures, non-solicits, and so on, establish if the contracts are going to be enforceable. You need to know, okay, I can draw up something great, but if it's not going to be held up, what's the point? Is it just for show? Is it just to, try and pull the wool over our LO's eyes? Or is this meant to, protect our backsides down the road? And if that's the case, you want to make sure that you are preparing it, or your counsel's preparing it in a way that's going to be enforceable in court, and, whether or not this is going to be something that is workable. Now, to date, non-competes have been dealt with, again, on a state-by-state basis, with states like the one I live in, California, banning them altogether. Some prohibit or for lower wage positions, which is kind of what the FTC was reflecting. And then some limit to inclusion with other elements such as expensive training. And then you have those that prohibit their use, altogether. Employers do include the non-competes as a way, as we said, not necessarily a show, but to discourage their employees. In most cases where employers actually try to enforce the clause, though, it has more to do with the data theft, the intentional interference with contractual relationship, and taking the consumer information. And that can be addressed in other contexts. So when the declaration by President Biden first came out, there was a lot of speculation that anything resulting from the order would be overly broad and include banning non-solicit and NDAs. But that doesn't seem to be, again, the case. And the non-solicit and non-disclosures are great tools that can and should be used. All right, so let's say, I think back in 2016, if I'm not mistaken, 2016, Congress had passed then the Defend Trade Secrets Act, DTSA, which acknowledged that protecting trade secrets protects the company as well as its employees. And then in President Biden's most recent term, it was he wanted to eliminate them altogether, except in those rare circumstances. So enforceability, always an issue that needs to be addressed, whether you're looking at the non-compete, the non-solicit, and the non-disclosure. And really, again, just make sure you ask yourself, the new language that you're using in your non-solicit and non-disclosure, are those so strict that they are tantamount to having a non-compete? If they are, then you have a bigger risk down the road. So again, make sure it's reasonable. Plus, I mean, at the end of the day, going to our next slide of finding the talent, if your people that are being recruited see an agreement that is so strict and they have, a high value of themselves, they may not, be turned on by something like that. And that could affect your ability to get them. But again, you have to balance the risk. How much money are you going to be investing? How much resources are going to be used? What is your downside if this loan officer or group of loan officers would bail on you at any given time? Now, lenders often go ahead and seek the high producing LOs from the companies because individuals bring significant advantages that can boost your growth, profitability, market expertise, and positive cultural impacts to hopefully affect other producers at your company and attempt to bring them along and increase their productivities. At the end of the day, it's about the bottom line. And it's about these LOs being your greatest asset, as well as a source of your greatest exposure. There is the conception that a top producing LO can hit the ground running, but hiring experienced MLOs, as I'm sure all of you know, with proven production records, reduces the need for extensive training and onboarding. And it'll minimize your initial ramp up costs. The top producers are often more self-sufficient, resilient, and have a track record of adapting to the different market conditions because we have certainly had our ups and downs from the highs of COVID or lows, however you want to look at it, to after COVID and to right now where, I was just over at the annual conference, and although I thought I would be seeing more rose-colored glasses being worn, when you really talk to people, they have a bit of trepidation about, where things are going to be going and all of the different concerns that are out there in the marketplace. Now, when you want to go ahead and attract these top producers, and that can also help with the retention of your own staff. When existing MLOs see that high performers are choosing to join your company, it will reinforce the appeal of working there, that they are at a great place, that they're working alongside. And again, as I had mentioned a few moments ago, help to generate more productivity by your other staff members. And it can just, in general, create a cycle where the talented LOs, start to look at your company because they see that too, and it will attract more and more talent. Experienced MLOs bring the insight sales strategies. They can also be seen as role models. In a competitive environment, top producers can increase the market share. The top MLOs come with a loyal client base and strong relationships with real estate agents, builders, financial advisors, and many of our clients and lenders hire top producers when it usually comes with the expectation that they do have that loyal client base and strong relationships to bring. Now, with that loyalty, that strong relationships, that's going to be a question for the former employer when they are looking at who leaves. Were those pre-existing relationships? Were those relationships created through, their investments? How were those? How were they originated, and how were they taken? That's something that is always going to be examined whenever these issues come up. Now, there's one reason I haven't said, and I can almost, I always feel it's being waited for, but mortgage lenders actively pursue top producing MLOs for immediate revenue generation. Top producers have a proven track record of high monthly or annual loan volumes. Bringing them on board will typically mean an immediate increase in revenue as they can generate that substantial business. But the immediate revenue generation is one place, again, that hiring top producing LOs can actually be harmful to your company. And I'm sure you can kind of see where this is going here. Let's talk about consumer privacy, which is always an issue that has to be looked at in these cases as well, because we've got the Gramm-Leach-Bliley Act. We have, data breach related rules that the information that LOs would love to take can't be taken. So what can they take legally? What belongs to them? What belongs to the company? Now, federal laws on consumer data privacy and data security cover various industries and individuals. Financial institutions, as I just mentioned, are governed by the Gramm-Leach-Bliley Act. The GLBA has gaps for different aspects of information security. And to cover those gaps, there are over 50 different non-federal data breach laws throughout the US. Multiple states have even enacted task force operations. How do you transition your loan officers? When a mortgage loan originator changes employers, there are strict legal responsibilities related to the handling of the customer information to protect client privacy again and maintain compliance with state and federal regulations. When an LO transitions to a new employer, they have to promptly comply with all privacy and confidentiality laws. The GLBA requires that the financial institutions, including mortgage companies, protect consumers' personal information. LOs have to ensure that they don't share, transfer, or take client information when moving to the new employer unless specifically allowed by law. Also, the Fair Credit Reporting Act regulates the use of credit information. So LOs can't misuse any consumer credit data that they have accessed with your companies and before they move over. And they have to ensure that any transfer or handling of the data complies with the act. And any states have any state law that you're looking at, make sure that you are indeed looking for whether that state has, and they probably do, a law, a statute on how to handle and manage consumer data. LOs, again, sign confidentiality agreements when they're hired on to your companies, prohibiting them from using or sharing client lists, loan files, sensitive information when they leave. And that is something that must absolutely be expected and is expected. But as we spoke about earlier, these NDAs themselves or provisions, are critical. When switching jobs, LOs have to avoid disclosing any of that information that may be covered in there. And they know really what they're not supposed to do, but there are some in gray areas. If they violate these agreements, then you have obviously a breach of contract action amongst potentially other actions. Normally, it's breach of contract. It can be almost something like theft, because if you have a valued asset and it belongs to your company and it is taken without authorization and it is violative of the law, I think people, and it helps to understand and maybe have a session like this, but in a different tone, to LOs, just to make sure that you're looking out for them. And so they understand the severity of what happened to other people, because you don't want that to happen to them and you don't want it to happen to your company. So there are ways to have trainings about these issues, to have gentle reminders. But again, that's something that you have to decide what is important culturally at your company. Do you want to scare the heck out of them and stop that? Or do you simply want to make sure that you are protecting your consumers? Or do you want to do both? And I think it's the latter. All right. Client lists, contact information, loan histories, and referral networks can be considered trade secrets. If an LO takes or shares this information with a new employer without your permission, it can be deemed of a theft of trade secrets, which is, again, illegal and can result in civil or criminal penalties. But I would caution you, and it's sometimes not, it's difficult to know where that line is, but it is illegal to threaten criminal action in order to get a result that you would like. So you can't say, hey, Joe, if you go ahead and you take this, I'm going to report you to the police and you're going to be put in jail. You can say something more along the lines of hey, I would go ahead and just caution you to look at this particular portion of the agreement and these laws and what have you, and understand that what our rights and our remedies are. Again, it can be black and white, but there is a gray area that is used all the time. And I use this, for instance, when I am having to go after a borrower for committing fraud. I'll ask them to look at the 1003, where they signed, what's it say? That way, you don't need to go ahead and make the threat. You let them figure it out for themselves. Now, in most cases, customer information belongs to your companies and not the LOs. The borrower relationship, however, belongs to the LOs generally, but not the borrower data, which is, again, the property of your companies. LOs can't transfer or use customer information, even if they were the primary contact, unless they have your explicit permission. LOs can't download, copy, transfer customer data to their personal devices, email accounts, or external storage without prior authorization. This includes removing any loan files or applications that contain personal customer data. And I can tell you, in one case I had a number of years ago, a former LO had gone to the office on a weekend with a van, and there had been a video camera on our client's outside wall, and we saw them going in and out with boxes of files. Needless to say, we made our client a lot of money on that one, but in many cases, you don't want to have to even get to that point. If you can save the money, if you can not have to go through the litigation route, that's always going to be preferred. So that's why dealing with these contracts are so important in a defensive preparation type posture. Now, the loans that are in your current pipeline legally belong to you as well. So all the borrowers that have been pre-approved, it doesn't have to be put into a formal system. It can be as simple as someone walking into a physical branch and the LO took notes, with pen and paper and a notepad. Although the data is the property, though, of your companies, the relationship, again, is one that is with the LO. So if a borrower is adamant about following the LO to a new company, there are compliant ways to handle maintaining that relationship, and your HR and onboarding process should account for those ways. Also, if LOs have been using company-owned devices like laptops or phones, they have to return those without any customer data on them. Employers typically have protocols in place for wiping or securing data on return devices to ensure compliance. The new employer also has a responsibility to ensure that the incoming LO doesn't bring or use protected customer data from their prior jobs. And companies need to train your LOs on data. It really comes to data handling practices, including reminding them of compliance standards around handling client information, from prior employers. But most important is when you are looking at hiring on an LO, it's not worth trying to get some immediate business by having them do anything that they should not do. Again, you're hiring these top producers because they have the relationships. They can go ahead and access those relationships. They can get moving again. A short-term gain is going to be a long-term loss if you do otherwise. Now, when LOs switch to employers, they often need to start fresh with new clients or work to reestablish relationships rather than transferring existing loans. There are, of course, exceptions. Let's say that you have an LO who speaks a foreign language, and his or her customers only speak that language, and you don't have anyone else at your company that speaks that language. Cases like this, you should just face reality that, what are you going to do? These people are going to go because, they have a rapport with that LO. And even if they were to stay, you don't have anyone at your company that may be able to handle them. So you need to look at these situational issues to, see where and when to fight and not to fight. So to summarize, LOs must handle the data carefully when changing employment in order to comply with the privacy laws, confidentiality agreements, and trade secret protections. Employers, your companies, should also have very clear policies and training to ensure data is secure, client confidentiality is maintained during and after a transition. And I tend to think that expectations between parties goes a long way in avoiding conflict. Conflict happens when you have uncertainty, when when you don't have a meeting of the minds. So the clearer you are on these issues, the better you're going to be able to protect your company. All right. Onboarding. So there's a few things that lenders can do to avoid the legal minefields of recruiting in our current environment. You should, again, ensure that your HR managers understand the restrictions placed on the new hire and are trained on compliance. Topics such as non-competes and non-solicits should definitely be part of the training so your staff can identify when they might be getting into a conversation that would require other managers. Lenders should include regularly review hiring and onboarding policies to make sure that the training and policies line up. That's something that not enough work is done on. These are issues that can be addressed in writing. You can leave yourself some flexibility, but again, the training itself, helping people understand what they can't do, what they can do, is a way that you can help save yourselves a lot of time and money. Having to deal with either an LO or branch that left you, or having to deal with the ramifications of bringing in a top producer and his or her branch, but losing a lot of money fighting a lawsuit. Now, lenders should clearly define a new LO or any new employee's role and responsibilities very carefully. Define clear boundaries within their role to avoid overlap with activities that could be seen as restrictive. For example, if a new employee has a non-solicitation clause, their job description should avoid hiring or building a branch. It sounds self-evident, but again, these are the types of things that have to go into thinking about making your contracts good. Document conversations with employees regarding their obligations under the non-competes or non-solicits. Keeping clear records demonstrates the lender's intention to comply with the MLO's prior agreements. Again, this is what do you go ahead and do here when you are bringing on a new LO? And this goes back to the recommendation to provide that training, as lenders should ensure both the hiring managers and HR team understand not to suggest any actions that could encourage the employee to violate their previous agreement. Your HR team should know what actions cross that line. Lenders should also ensure that your onboarding materials emphasize ethical conduct. The material should include the importance of respecting confidentiality and data privacy for both the former employer as well as the current one, making instructions to the new employee to avoid recruiting or contacting former colleagues and for consumers. The materials in the form of policies and procedures or training decks can also help protect you if that top producing LO decides there are greener pastures. It's also a way to remind them again of their confidentiality obligations. Now, whether a lender or an employer directly asks a recruit if they have a non-compete or non-solicit agreement with their prior employer is it's a debatable area. On one hand, asking allows for a careful review of the incoming employee's non-compete and non-solicit agreements from their prior employer, if one exists, and to understand any restrictions on location, industry, specific roles, and prohibited activities. This careful review may include seeking legal assistance, of course, to interpret that. The more you know. Well, I guess you have to look at the other hand, though, which is what we have to face. It could weaken any plausible deniability or other mitigating claims that you may have had. Most employment agreements for LOs, or at least all the ones our firm draw up, include a clause of assumptive disclosure. Paraphrasing, the clause states that if the employee has any restrictive covenants with prior employers, they already told or gave the agreement to the hiring employer. By not asking about non-competes, employers may believe that they reduce the risk of being accused of tortious interference, which is the legal claim that one party wrongfully interfered with another party's contractual relationship. There could also be state implications that promote not asking because the state statute doesn't recognize restrictive covenants or actively prohibits asking due to discrimination concerns. In practice, employers have different approaches to handling the restrictive covenants. Some may not ask due to a combination of the factors I mentioned. Some may ask only in later stages of hiring, and some may ask right up front. And this will be a decision that you will have to make with your counsel. All right, and I do see that we are coming up on the 1 hour mark. And if you cannot stay for the remainder, I'm hopeful, and I'll have to ask Mimi, that a recording of this will be available so that you can catch up on what you may have missed. I'm just going to keep going until they take that cane and bring me out from speaking. So, but this presentation will be made available to every one of you. Again, we will make sure that any questions that you have get addressed, complimentary, no charge. We just want to make sure you get the most value out of this because it is, a very important issue. Now, I want to go back quickly to some of those headlines that we had talked about earlier on Guaranteed Rate filing the lawsuit against its rival for poaching. And it's unique for another reason, though. The lawsuit stated that to achieve its goals, the competitor allegedly used illegal compensation practices to induce the employees to resign and incentivize and encourage those employees to solicit and recruit others to defect to the new company. Now, there's no doubt that there is a rise in poaching lawsuits due to the competitive market, but this lawsuit is the first time that, again, a large lender had publicly accused a competitor of violating the LO Comp rule, which, we have to deal with LO Comp enough. But now you're having to deal with it in this context, or at least, between the competitors, because again, as I said earlier, anytime we go after a loan officer or a branch, they will always attempt to use LO Comp or compensation or HR issues as a way to offset or deflect from whatever exposure they may have. All right, as you know, LO Comp rule went into effect back in 2014, and despite the fact that the rules have been in place for many years, some changes and evolution to the rule have taken place, and what we see with the Guaranteed Rate lawsuit, and as we see from clients, there are still inquiries and misconceptions about LO Comp. As a result, we want to make sure that you have some of this additional information to better understand it. All right, first, the rule prohibits a lender from compensating an LO based on loan terms or a proxy for terms other than the loan amount. When determining if a factor is a proxy, there is a two-part test asking whether the factor consistently varies with the term or terms of the transaction or over multiple ones, and the LO has the ability, either directly or indirectly, to add, drop, or change the factor when originating. The rule also prohibits comp from both the consumer and another person, meaning the LO cannot receive a commission from both the borrower and the company, as an example. All right, here I put in, I'm not going to go through all of this in the interest of time, but I did put all the safe harbor methods that you can be looking at. Um, three of the methods though that I do list are fairly common, and that's compensation based on overall dollar amount or overall dollar volume, hourly pay rates based on number of hours worked, and fixed amounts such as $600 for every credit transaction arranged for the creditor, or $1,000 for the first 1,000 credit transactions arranged. The other four methods outlined in the rule are frequently overlooked or underutilized, though. These methods are the long-term performance of the originators, new versus existing customers, percentage of applications that close, and the quality of the loan originated files, such as accuracy and completeness of the loan documentation, since you can't really do clawbacks because you don't know whether or not that income has been considered to have been earned under your state's laws. So it has to be forward-looking when you're looking at these quality metrics. Now, all seven of these methods can be used in conjunction to achieve, your goals here. All right. I give you a lot of information with regard to that LO comp because you need to, when you are considering going after an LO or considering an LO that may leave, not wanting to throw this in your face, it's important to understand. And since you have to go ahead and tighten up your agreements with your LOs, and you don't want to go ahead and do it multiple times, better to go ahead and address these issues all at one time. All right. Now, I'm going to quickly go over some comp or examples of popular permissible comp structures, but also structures we commonly come across that you should avoid. And that's there we go. So we've got the permissible, non-permissible, and then you have the gray areas. And this is something that you should take a look at internally with your counsel and make sure that you are putting together an agreement that's going to protect you in all the different circumstances, but most specifically on what's going to happen when you have a pissed off LO that leaves, or you are the one that's pissed off, and excuse the language, but that you just had someone take proprietary information, data, employees, and customers. And again, going after them for compensation, going after them to set an example, and just making sure that you don't, your companies aren't left in a bind because they failed to exercise those rights. But you also want to make sure that you have a reputation, because that is everything in our industry, and I'd probably say all industries, but understanding in our industry that you see these companies, you see these executives 20 years, 30 years, day in and day out, you want to make sure that you maintain that relationship. You don't want to have to be filing litigation with your, even though it's a competitor. I mean, you guys are going to be walking in the same circles. You don't want to have to do that. It's always better if you don't need to do something that you shouldn't be doing, that you don't. And I guess it's easy to say don't get greedy, but the other part of that really is that it ends up really backfiring, because by the time you're done with the litigation, by the time you're done with you being in the headlines, the time you have to see other LOs leave because they are concerned about where they're working. I mean, those are things that could be detrimental to your companies, and you don't want it to happen. All right, so let's skip ahead. We're already 6 minutes after. Okay, I get into, let's say, now, things you're going to want to talk about, I'll just go run through it really quickly. But there are various ways that you can deal with the compensation to try and retain the talent so that they don't leave to a competitor. Ways that it's done is various lead source options. you want to go ahead and you can have various product options. All right, and then let me try to wrap it up here. In addition to the LO comp, we also have information on the dual employment, dual capacity, and conflicts. There's a lot of significance here. I put it in very clear terms when you are reviewing these slides. And I welcome you and highly recommend that you do read that. Also, that you do take a look at the UDAP. Let's see. I think we are pretty much good because we are really out of time. And Mimi, I apologize for going over, but hopefully the audience, the attendees had gained some good insights. Again, this is something that we do day in and day out, both from an offensive prosecuting and a defensive posture. So if you have any questions, I welcome you to provide them to Mimi. Feel free to call me. But otherwise, I'll give a follow-up FAQ to you, Mimi, and you can use that and submit it however you'd like.
That would be great. Thank you, James. This was terrific content. Now, I know that a couple of people have stayed on because they had some questions. If you have a minute, would you mind answering a
Yeah,
couple of the questions? And then we can include it in the recording for them. Does that sound okay?
that sounds great. Let me make sure I can pull those up here.
Okay, here, I can share them with you.
Yeah, go ahead and do that, and I'll be happy to address them.
Great. Here are a couple of the questions. How can third-party recruiters assist in non-solicit situations, and do they have liabilities?
Um, Third-party recruiters, they can be helpful. I mean, again, if you want to set some distance, but understand that they're your agents. If they go out and they do something that they're not supposed to, I mean, as you all know, with vendor management type rules, what your potential liabilities are there. The third-party recruiters also have their own exposure. If they do something, let's say they go after, they ask a loan officer about their agreement. And the loan officer tells them that they do have an agreement that has, where they, has a non-solicit, non-compete and all of that. And they go and they say, well, why don't you still come over here? Well, they could
Mhm.
be held liable for intentional interference with a contractual relationship as one part of that. And the principal, the company that hired the third party recruiter, could also face liability depending upon what it knew, didn't know. And I would just say that when you use a third party recruiter, I would look over their contract in depth and make sure that they have insurance, make sure that they have you have a paper trail of what they will do and what they won't do. But again, third party recruiters can be a great resource, but it's certainly not a magic bullet that will get rid of all of these concerns that we've talked about.
Okay, thank you. And then what data regarding the relationships? What data regarding the relationships, name, phone number, email address can LO take, bring if the relationship belongs to them?
Yeah.
What should we allow them to take and what should
Yeah.
we allow them to bring?
So primarily, you want to make sure that you are only bringing things that are publicly available, names, phone numbers, email addresses, and there should be no ability or no paper trail of them copying that and bringing it with them. But again, the relationships are the loan officers, the data is the employers, but you can go ahead and have other ways to find out that information. But again, and I think there might be some aggregators that you can chat with and what have you. But again, you want to make sure that you don't have any track record of downloading, forwarding, emailing this, and understand that if you have a lot of people leave at the same time, well, there's going to be a paper trail somewhere. I mean, people don't just do that without some level of coordination. And so when there's smoke, there's fire. And I would go ahead and, make sure that you have your IT people, as we talked about earlier, address that for you.
So thank you. Another question, how
Yeah.
far back can you go? Um, I lost a team 2023, and I'm sure they took away too much customer information.
So the statute of limitations, how long you can pursue that, is really a state by state analysis. Let's say in California, the statute of limitations for a breach of a written contract is 4 years. In states like Missouri, where I litigated against City a lot, and may have changed since those days, but it had been 10 years. Certain types of actions have a very short period of time, as much as 1 year. So I wouldn't sit on it if you have a concern. I would have it evaluated. Take a look at what your expectation can be. Uh, with a lot of time passing, it may not be something that you want to do. But if you found out as you went that a hell of a lot of money was taken, and you can, I think, safely assume, I believe you said you did, that there were things that were done that should not have been done, and that's probably right. It's just figuring out what the damages are, whether that's going to be worthwhile, how it's going to impact you in other areas of your business. But those are the types of questions that I would be asking if you were a client and we were talking about this right now.
Thanks, James. Couple more. Can we drill down to non-solicitors and how to handle when a new hire received a cease and desist? We don't really see the non-competes as often.
Yeah, so it's like the modus operandi when you have someone leave. You'll get generally, or I do, and I both respond to them as well as send them, but cease and desist letters to the former LOs as well as the new employers to put them on notice. And if you have someone, a competitor, who is sending you that and also sending you a demand, well, it's really a fact by fact type of deal. But if you think you have something to be concerned about, then you want to be more concerned about it. And I would say to contact your attorney. If, for instance, you think it was done, above board, and they're just, firing out this demand as a way to, scare you or what have you, it may not be as important. But again, it depends on the circumstances. Depends on the situation. When you are getting these LOs onboarded, you just want to make sure that you are, you're not having any discussions. Hey, I'm going to go ahead and solicit Joe Smith or Mary over there. And if you do get a lot of LOs or a whole branch, I would make sure that they all go through the actual employment application process, that they submit an application, that they don't just automatically come over. Now, it could be somewhat of a foregone conclusion that they're going to be hired, but the more evidence and track record you leave of doing things above board, the better your counsel will be able to protect you if and when it comes to litigation.
So one last question, and this is a longer question. Outside of training and papering policies to the heavens, what type of safeguards can a company put in place to stop LOs from maintaining consumer information on a non-secure personal server? Also, if it is found that a former employee leaves with borrowed information or on a private server, at what level does that need to be reported as a data breach?
So I have when you're looking at the data breaches and what the numbers are before you have to report it to, say, the state attorney general, sometimes it's as simple as one. Sometimes there needs to be many instances, but it is a very, very important issue because, as I'm sure all of you out there are looking at your insurance coverages, understanding that cyber policies are huge, a huge expense and a huge need in this day. And if you end up having a cyber problem before you actually have insurance, you may become uninsurable for that. So, it is a very broad area, but it is something that has to be looked at anytime an employee leaves, because if they did carry that non-public private consumer financial data, you're going to need to address it. Now that's an area that when I send out a demand letter to the new employer, if I find out that that happened, I'll be telling them any of the losses or any of the harm that comes to me from that data breach. You can be sure I'm going to be asking for that either in a lawsuit or, preferably you just sign over this agreement, give me the money, and we'll let things get resolved without the courts.
This has been very informative, James. Thank you so much for sharing this information with the
Yeah.
team. This is a recorded session, and we will be sharing the recording and the presentation with everyone after the fact. I'm glad you were able to answer all the questions that they had posted on here, James, and it's recorded, so it will be
All
shared
right.
with everyone.
Well,
So
listen,
thank you so much for your time today.
yeah, no, thank you, Mimi. I really appreciate it. And thank you, everyone. I know it was a long session, but hopefully you got some value out of it.
Absolutely. Thank you, everyone, for joining today. We hope you have a great afternoon.